this is actually not a case of data breach, but a case of data leak. Let me paint that clearer. Now, when someone is arrested, maybe you're driving and suddenly somebody jumps in the middle of the road and you crush the person. Now, when that fellow is arrested and taken to the police, the first assumption is that, oh, he has committed murder. He killed someone. Or maybe somebody comes to your house and you don't reach out for your double-barreled rifle and you shoot at the person. I mean, the view is you have committed murder. It is after investigation that investigation will now establish that no, this is not a case of murder. It's a case of manslaughter. Or this is not even a case of manslaughter. This is a case of self-defense. So, but every issue of data getting into unauthorized hand has to be first viewed as an incidence of data breach. You are safe to see it from that perspective. That's number one. Number two, when we are addressing these issues, all of these issues, as lawyers or as law students, please let us always fall back on the extant regulation or legislation as the case may be. Like I said, the only extant regulation we have for data protection in Nigeria today is still the NDPR. And we have is regulations 2.6, 2.7, and 2.10 provided for it. What do those regulations say? Do they recognize data breach and data leak or only data breach? So that actually will enrich our view, our assessment, and an analysis of the situation. But strictly said, data breach and data leak are not exactly the same. Just like when we come up with data protection and privacy, they are not the same thing.
Thank you very much, sir. For that answer, I'll be asking the next question to Mr. Emmanuel. What are the common challenges and barriers organizations face in effectively managing and responding to data breaches?
Thank you very much once again. And I must give maximum credit to Mr. Solomon for giving much touch on that first question. I really appreciate his position on that. Now, to this question, the common challenges that that organizations face when trying to manage and respond to data breaches. Now, the first and foremost is actually the lack of preparedness. And I would say that is the primary challenge because most organizations, especially in Nigeria, are not prepared. They don't have a proper data management plan on ground. And in that instance, where there is a breach, they'll have delay on how to respond. They don't know how to respond. They don't know how to assess, how to even dictate in the first place. So this is actually a very big challenge, the lack of preparedness. And another challenge that definitely is on top position is actually limited resources, because having a solid data data breach management plan can be expensive and also time consuming. And trust me, most organizations, they don't have these resources. And when I say resources, I'm talking about personnel, I'm talking about technology, I'm also talking about financial implication as well. And so with poor investment or poor allocation to such response, be rest assured that this will bring about limited resources, and where there's a data breach, this will affect how they will approach it. Another challenge that they may encounter is the complexity of the data breach. Now, as we have heard from the whole process so far, data breach could come in different forms. It could be phishing, social engineering, any form is coming. So now the complexity matters a lot on how it will be detected, how it will be controlled, and how it will be mitigated. So in this instance, a lot of organizations have challenges on how to handle complex data breaches. Then another challenge is the one that is very common, especially in Nigeria, is like trying to protect their reputation. In a bid for an organization to protect their reputation, they tend not to even bring out some of these data breaches. They don't report and they don't make any action. At the end of the day, instead of escalating it, they'll try to hide it under the carpet, and this whole breach will keep expanding. So I think organizations must learn how to be transparent enough to make a rapid response and sort any form of data breach. And I'll say that now, okay, I've talked about lack of preparedness. I've talked about the limited resources. I've talked about the complexity. I'll sum up by saying that to effectively manage and respond to data breach, organizations they must have this top-notch approach. They must have a proactive team. They must have resources on ground and be prepared. And most of all, they should have a data breach management plan on ground, which will help them handle such issue. Thank you very much.
Thank you very much, Mr. Emmanuel, for that wonderful answer to the question. I can see God's love hand is raised. I don't know if you have any question you can ask immediately before I move on to the next question.
Okay, thank you, Mr. Hussein. Thank you also to our mentors for a great job. I want to find out, there are times where there's a data breach. For example, someone is using Facebook, and the breach on its own is not just due to the negligence or lack of proper, should I say, avenues or know-how to protect this data. Probably someone uses, there are some apps you want to open, and then they ask you to use either your Google account or use your Facebook account. What happens where the user, the owner of that information, is the reason why their data was actually breached? Who then, and it was breached, probably you try to log into a game app, and the game app says you can either use your Google account or your Facebook account. You use your Facebook account, and as you log into the game, over time you find out that they have hacked Facebook and your account over there. Now, are we going to blame just the person in question, that's the user, the data subject here? Or are we going to also blame Facebook for not having per se adequate protection for their app against breaches? I think the mentors get my question, please.
Okay, I'll give the floor to Mr. Solomon and also Mr. Emmanuel. Mr. Solomon can go first.
Okay, a brilliant question, at that. So one of the things I will say is this, and I think many of us, particularly those. Hello?
Yes, sir, your network went off.
Yes, we can hear you now.
Okay, can you hear me now? Okay, so
Yes, sir.
Thank you. I'm sorry about that technical glitch. Okay, so like I said, now those of us who run litigation maybe will pretty much understand a smart approach to that. Now, I'm in a situation where I cannot actually say that, look, it is the cause of Google or the owner of the app that actually immediately, occasioned the data breach. But you see, one thing I can establish, that Google offered a room to, let's say, fish mail as an app. Google offered a platform for FishMe to host its app. And I got my data breach. My I got my data breached on Fishmill app. Now, Fishmill app is sold by a separate data controller. But the truth is, now I'm not even too sure of what played out, whether Google clearly enabled that breach or some other things happened. Now, all I need to look at is, let me create a scenario for myself that, look, I am actually doing business with someone who owns a shop or occupies a shop in a business complex. While my car is parked there within the complex, then my car is stolen or my car got damaged. In that case, in that situation, if I'm going to actually commence a litigation, I will not just only make a claim against the owner of the shop that I'm directly dealing with, but the owner of the business complex, the building, not just because my car is parked there, but because he enabled them to run their business in that place. I'm not too sure what could have happened. Or let me paint it here. Let's assume that the business I'm dealing with them, maybe I've asked them to let me print some shirts. And I just come up and I heard that, and they just told me that, okay, look, maybe I gave them yesterday, and I went there this morning, and they told me this morning that, look, our shop was burgled and your shirt was carted away. Yes, I could say, oh, look, I only want to deal with the people I gave the job to. But what if the circumstance around the way they gave the shop to them actually allowed the owner of the shop to have even taken it away? And I think the best thing I can do is to comprehensively deal with the issue. Let me rather join the owner of the shop or building, the owner of business that I am directly contracting with. So at the end of the day, when we get to court, you know what will happen? What will happen is, by the time we file the processes and all of the two respondents file, if the owner of the building is not in any way related, it will be the one to tell the court that, look, my lord, I do not control how they can enter the shop. I do not, as a matter of fact, I went overboard to tell them how the shop could be secured, and I did my bit. In that situation, then he has passed the burden to the owner of the shop, the direct business I'm dealing with. But if, maybe while doing that, the owner of the shop can say, oh, my lord, that's not correct, that's not correct. In fact, he has a spare key. His wife, when all of that now happened, you now realize that you are actually smart. So when the court also now looks at it, if the court finds out that the owner of the building is not in any way responsible, the court will actually, dismiss the case against him and sustain it against the owner of the business that I am directly dealing with. But if the court can look at it and no, you also have a body. If you have done this, this will not have happened. If it's not by permission, by omission, you have done something, you refuse to do something that allowed the data subject's data to have been breached. So for me, the two of them are ordinarily or generally responsible.
Okay, sir. So why not in the case where the data subject as well is at fault, in the sense that when he opened up an app and linked his physical Google account to an app that was not really so secure, and then he's crying wolf by saying that the Google software did not provide enough protection for his own data, that even if probably by mistake he has put his app through another app that does not really hold his data. Now this app, through his info per se, has been able to breach his account and his information on Google app. And data service is now blaming Google for not providing sufficient data breach management and cybersecurity and all those things for the data he has, thereby preventing him from having his right to privacy as they have provided for in their privacy policy. Would that hold water then?
Mr. Solomon, I don't know if you got that or if he's still with us. So I'll give the floor to Mr. Emmanuel to also contribute to that question.
Okay, I'll just give a very short answer, and I'd like to make reference to the fact that you mentioned that in the event that the data subject is also guilty. Now that is where impact analysis comes in. Now there will be a deep check on where the fault is, who is responsible, how it came about. So this is more of I would say within the discretion of the court to make their opinion. But generally, I would say that where the data subject is at fault, certainly he will have to bear the whatever may have resulted from the data breach, but is left for the court to determine who is actually responsible and what penalty to issue. I believe Mr. Solomon, that is so experienced with litigation, can share so much light on this.
Okay, so that means that a data controller can be able to sue a data subject who probably was not careful enough with the data he has given to them, and by such tampered with other data controllers that enabled them to breach their own softwares to gather data or to get hands on data. Could that be possible? Do you think so? Where, for example, this same scenario where the data subject has been careless with data he has submitted and has linked probably a different data controller to maybe a hacker, unknowingly thinking that was a genuine source. And now through this source, there is now a way into this other data controller, and they actually get other data from this data controller. In that case, can a data controller then sue the data subject for being, let's say, the edge that was broken, the serpent is biting, the medium through which a hacker was able to get into their own data bank to get people's data?
Hello?
Yes, sir, we can hear you, sir.
Okay, so maybe I quickly jump on that. Now, so let me start from, from a basic analogy that we can relate to. Many of us actually that have bank accounts with Nigerian banks, from time to time, we see those banks coming on social media platforms, Twitter, Facebook, and saying, look, we do not require our customer. Let me call you back. Can you hear me?
Yeah, we can hear you now, sir. Your voice was breaking earlier, so I think you can.
Okay, so like I said, many of us who bank with Nigerian banks, we have actually come across them on social media platforms, Twitter, Facebook, saying, look, our bank will not require you to drop your BVN by a phone call. Our bank will not require you to do this, to do that. Now, they know why they are doing that, and I'll tell you why. Now, they know that if for whatever reason, your bank account is hacked and your money is taken away, through that, they will come before the court and put up their defense that they are not liable, that was your own negligence. But then, and I know that the moment you are summoned by a court process, you are banned to make a representation in court. And making a representation in court is not free. It's not free. So that exclusion clause on the part of the data controller is to save them from, Yorubas will say, meaning I wasn't there, alibi. I will not, in fact, what they want in this situation that we don't even want to come around. We don't want a situation where when they put up such a notice, if they should have had about 100 lawsuits, such lawsuits would have been significantly reduced to about 80. Because some people say, no, guy, you say you don't read that, don't see that thing. If okay, come and see it. You can read this. Our bank shall not. You are the one that now, let's not go to the point of what you said that, okay, the data controller here is, yes, like a caveat, of course, in contract, generally, you call it exclusion clause. You want to exclude yourself from responsibility. Now, so when you look at it, the scenario you painted, that through your unauthorized or your extensive use of the digital platform, you strayed into another platform, and that has occasioned an attack, or a compromise of their own storage facility. Well, in that situation, the data controller becomes the complainant. What I mean complainant now, not really in the criminal view, I mean, it's the one that is complaining or alleging that you have occasioned something. And in that situation, all they need to do is to now investigate whether that was intentional or not. Who could have done that? But then trust me, most of the time, all of this a data controller will be such protected that for you to attack, it will be a direct or targeted attack. In that situation, the scenario you painted will most unlikely be untargeted. Most likely will be targeted. So in that situation, then you're not even a victim yourself, because what you're saying is that you are a victim and you have actually made them a victim, right? But in this situation, now they would rather see it as you're being a victim is actually to create yourself, to create a less evil up to you to gain sympathy when they were actually the target. So we understand how terrorists launch their attack. The suicidal bombers, they will try bomb around themselves. They know they're going to lose their life, but their own life is just a collateral damage. They know they want to ruin a whole city. So for me, I will not see, no state will see such a suicide bomber as a victim, even though he has suffered a loss or his family has suffered a loss. He's not a victim. In fact, if we know, no suicide bomber will have his family stepping forward that we lost our dear son in your plane. No, he was bombed in your plane. Nobody will step forward to say that, even though they have suffered a loss, because the greater loss will be viewed to be the target, not him listening. So I think that's how it plays out.
Thank you very much. I hope that answers the question. Goslow Kamali. Thank you very much. So I'm still encouraging our mentees to ask questions. You can raise your hand and I'll call on you to ask the question. I'm taking the next question from Mr. Solomon. When organizations such as Google reach out access to data of person gives this information to other, give this information to other companies advertising their brand. Will a breach in personal data be said to have occurred? I think without the data subject's consent.
Yeah. Well, I think, but when you look at it, a part of this question have actually been taken. A part of it has been taken in the look at the other question we just discussed now. But one thing is clear, even when you look at the provisions of the NDPR 2019, as a data controller, there are instances where a third party will be involved in data processing. And I can tell you categorically that maybe you may hardly find a business today a serious business that won't have to involve third party in processing personal data. I think I doubt it. Even as small as let's say a small business, maybe you're into printing, and you get a printing job while your computer operator types the text, you design. After you have finished the designing, you give it to the operator that will operate it, or somebody that will cut it and all of that. When that is happening, a third party is involved in the whole processing ecosystem. And in that situation, now I've only used that as the simplest analogy to give us a picture of how it works with mega corporations, whether it's Meta or Twitter. In that, with them, there are lots of third-party processors involved. So the position of NDPR, which is also the position of almost all regulations and legislation, is that the moment you engage a third party to process a personal data, you need to ensure that you pass on the burden you carry onto them, or at best, you share the burden with them. They become, with due respect to the faith people, church community, they become what the people in ministry will call burden bearers. They burden with you. So, and in NDPR prescribed that you have to prepare a contract with them. So that contract will show that they have that burden to see themselves as a data controller to all the data subjects they have. They have their data with them. From whom you transfer their data to them. So when you look at this, then whether it's Google or Apple or Meta or Twitter, it's the same thing. It applies with the law. But first, is the situation that the law says, look, they become burden bearers with you when it comes to data controllers' responsibility.
Thank you very much, Mr. Solomon, for that answer. I don't know if Mr. Emmanuel also have a contribution to that question before I ask the last question.
Okay, I'll just add a little to what Mr. Solomon has said, because I'm really aligning my position to his. Now, just as he said it, the moment there's a third-party involvement, automatically that third party becomes a processor. And as a controller, the processor is supposed to be bound only by your directive. And any action or any breach that may occur as a result of such, both the processor and the controller are liable. So in that instance, I would just say that they may have maybe legitimate, they may claim legitimate interest, or probably if it's in regards to health issue, they may want to claim vital interest, but nevertheless, the position of consent can never be taken away. The data subject must be fully aware of who is processing his personal data and what his personal data is being used for. So that's just my position on this as well. Thank you.
Very apt position, I must say. Mr. Emmanuel.
Thank you, Mr. Solomon.
Thank you very much, Mr. Solomon and Mr. Emmanuel. I'll be asking the last question to Mr. Emmanuel, while Mr. Solomon can also contribute after his answer. Okay, in Nigeria, what actions can data subjects enforce or take when their data has been breached?
Mr. Mada, please, before you say a word, sir.
Yeah.
I doubt if we should be made to answer that question. You know why I want to say, I can tell you that almost all the mentees here have an answer to that question. Trust me. I mean, these guys made brilliant presentations.
Mm-hmm.
So you are asking me that they don't know that there's administrative remedy and there's a judicial remedy. They know that now. These guys are only being humble. If you to the courts now, you will realize how they will go to the court and start getting damages and all of that. But simply put, I'm sure I do not just want us to the whole essence of mentoring is not meant to teach really, but to guide, to correct. And with the presentation I've seen, this is the list of a question for mentees on this platform. The guys, they are fantastic. Trust me. Unless Mr. wants to answer the question.
I agree with you. I agree with you completely. I agree with you completely. And instead of even going into the whole details, I will tell them that if they are in such position, please go for outside cost settlement and enjoy more benefits.
All right, thank you very much, our both mentors. So for those of us that don't know what to do, our mentors have given us as a take-home assignment to go and research.
They even do. We have mentioned administrative remedy and judicial remedy. Administrative remedy, yes. Write a petition to National Data Protection Bureau. They will take your bit. What is it called? Judicial remedy, go to court. But the only distinction oftentimes is that for administrative remedy, till date, the supervisory authority, which is NDPP and its progenitor or predecessor, NIDA, what they have done mostly is that they have imposed fines. They have not been able, and because that law does not actually allow them to grant damages or compensation to data subjects. So if what you need to do is to punish the data controller, go to NDPB. If what you need to do is to make money from them and get an order of specific damages, get injunction, go to court. If you want to attack them from right, left, and center, go to court and still go to NDPB. The beautiful thing is that NDPR states clearly that you're approaching the supervisory authority does not, and as a matter of fact, can never foreclose your right to approach the court. So like I said, I still come back to what I said, administrative and judicial, simple as ABC.
Thank you very much, our both mentors. I believe we all had a very interactive session today. Thank you very much, Mr. Solomon.
I don't get something.
Thank you very much, Mr. Emmanuel Ewewe.
Miracle
also being here.
Miracle wants to say something. I think Miracle wants to say something.
For administrative remedy that you can apply to which of the body?
NDPB.
Okay. Thank you.
Yes.
Mr. Goslov, I don't know. Do you want to give us the closing?
So what is probably privacy policy or terms and conditions? There's a provision for arbitration. What is arbitration clause there? So how about going to the arbitration panel as well?
See, that's not a bad idea. But when you look at it, when you go to arbitration, I've actually not, in all sense of honesty, I've actually not taken a data protection matter to arbitration as a date. And trust me, we'll still have to be doing that. But we know clearly that when issues come up around data protection, the first thing we want to do, or the data controller wants to do, is to deny responsibility. And trust me, our arbitration fora we have as a date may still want to wait first, and let us have a situation where the courts have made interpretations, have actually given expansive opinions, rulings, and judgments on principles surrounding data.
I think we lost Mr. Solomon. His
Okay.
network is very poor. I can see from here that his network reception is bad. So let's just give him a second to be back. Okay, Mr. Emmanuel can step in on the answer to that Godslove last question. I think Godslove, you can. Okay.
Please, can you share the question again?
Mr. Solomon is here. Let's just hear from him first.
Okay.
So we
Okay.
lost you for a minute. Your
On
network
what?
was bad.
Okay. So when you look at it, if we're going to give example of tenancy in Nigeria, now I could imagine what it was going to be when we had not had much judicial pronouncement on applicable notices. If you are a yearly tenant, a 6-month tenant, or a monthly tenant, I will now go to arbitration, whether formal or informal. And somebody says, Mr. Goslov says, look, I gave him notice. I said, my lord, he gave me 29 days. And the 29 days, that's a month now. Now, it was I gave him a month. I said, but you gave me 29 days. What are you saying, guy? He gave you 29 days. That's a month. How many? So, in fact, February is even 28 days sometimes. But when he gave me the notice, the 1 month notice, he gave me on 1st of March. Then it or maybe he gave me 2nd of March, asking me to quit the apartment on 30th of March. So, and a third party can say, God, it's 4 months he gave you. But the position of the law has been that, look, 1 month has to be complete calendar month. You cannot give me notice by 2nd of the month and expect it to terminate by the last day of the month. Now, why this is very important for analysis and understanding is the fact that the courts have made the works of the arbitration fora easier. Because when you go there, nobody will go to Montreal courthouse, whether in Kenya or Lagos Island, and begins to say, I gave him the notice on 2nd, then by 30th he has to leave. They will say, no, that's not complete. Because there will be judicial interpretations of that position of the law. So I think why we hope to have, because the whole essence of arbitration is that when we look at it, arbitration is just like a brother or sister to litigation. They are both dispute resolution mechanism. So, but because litigation is the mainstream mechanism, then we call arbitration and its siblings or cousins, we call them alternative dispute resolution mechanism. So for me, will have been made. Because if we do not do that, I'll tell you what will happen. If you have not done that, I want to jump into arbitration now immediately. We the courtroom. Because arbitration is actually meant not to be adversarial in nature. So if the courtroom have done most of it, have given us enough interpretations, by the time we are going before arbitration, even as parties, we know what the positions are. And that's what I think. Because today in Lagos State, an average tenant understand. In fact, some tenants can analyze some tenants. You would think you call them experienced tenants. They can analyze all the notices to you that you are a lawyer, and you all always agree with them because they have come across it repeatedly as the court has interpreted it. So I think that's my view.
Okay,
thank you very much, Mr. Solomon. I also call on Mr. Emmanuel to contribute to that answer.
Okay, let me just add a little to this because I see it as subject to jurisdiction. Like in the EU, there are a lot of laws and also the statutory authorities. There are fines and other sanctions that have been put in place. So where a data subject is having that opportunity to explore those options, now he may resort to alternate ADR, and in such instance, he may have the upper hand to even bargain more and get better. But in Nigeria, I would say that the NDPR is more advisory than more of a law. So I think that there's less more to achieve from that regulation until we get the bill. And I'm happy that Mr. Solomon is very, very, very familiar with the NDPR, and he knows that is more advisory and there's less or more that effect on such sanction. But talking about the EU that I'm very familiar with, I'll say yes, ADR works very well, and the data subject can explore that option and benefit so much from it. Thank you.
So let me also quickly make an addition to what Mr. Emmanuel said. When you look at what he said is just something like painting a clearer picture. I said, and like in a reverse way, I'm going to say that. Now, if you look at it, GDPR was actually issued in 2016, May 2016, but enforcement did not begin until May 2018, giving authority 2 years of sensitization. Guess what applies in Nigeria? NDPR was issued on 25th of January 2019, and enforcement began the same day. You know, it was only some part of it months for I think for privacy policy, maybe 6 months for audits, for returns, and all of that. Now, even in EU, Mr. Abana is here, he can confirm that they had 2 years of rigorous sensitization. There are still big challenges here and there. Now, thinking about a place where, okay, we have the law today, the law commences today, haba. So, an average European citizen is more informed about rights, regulations, and legislation than an average African citizen. And that's a fact. That's why they're so confident in their judicial system and other systems. So that can perfectly work in EU today. Here, not that we cannot attempt it, but my honest view is that we need to have actually killed some hurdles. We need to have gotten the court to have given us interpretations of some. Okay, for example, but the moment the bill is passed, then we now have done NDP with the Data Protection Act. So that act needs to be picked up. What are the provisions? Well, now we have not been invited. Mr. Emmanuel, that's what your country of death has done to us. Public hearing was not done for that bill. So that's not the problem. I can assure you that that bill will be attacked in court because that was what happened. That was what they did to Cybercrime Act. And that's why till today, we are still challenging the Cybercrime Act, and we still have 2 cases, 2 appeals at the Supreme Court. So basically, here we hope we'll get to where Europe is. But I think we should not want to have a child born today and that child starts calling daddy, mommy today. Let's take the walk before we start flying.
Thank you very much, Mr. Solomon. Thank you very much, Mr. Emmanuel, and everyone on the call today. So personally, for me, it's very enlightening. I believe all our mentors learned something from today's session and go back home informed. Also to our mentees that present, I believe you all take corrections and we'll do a better presentation for those are lawyers, mentees, and for those of us that are not lawyers too. Okay, Mr. Solomon, you have something to say before we end the session.
Yes, thank you, moderator. I was wondering that the other group did not finish their presentation. Are we accommodating them the next session, or it's empty? If it's empty, maybe I will just give my view, my comment on their presentation, because I read their slides already.
Okay, sir, but I still can't see the person presenting back on the call since when we came back. So that was why I didn't.
Okay, no problem. That's what I'm saying. That's what I'm saying. It looks like we may not be able to take that presentation the next class. Then maybe I should just give my comment. It's not a brief.
Okay, sir.
It also has, so that's to get them to improve or whatever they have. They send it to improve. So
all right, sir. You can go ahead, sir.
Okay, so I'm going to be very brief. So their presentation, for me, I don't know what view Mr. Emmanuel shares. If we're going to compare the presentation of the slides, I think this particular group that did not finish their presentation have a more beautiful, more attractive slides. I start to be to be overruled.
I agree.
But,
I agree.
Sorry?
I agree with you. I 100% agree with you.
Thank you. So I want to believe that our corrections the last time actually impacted on what they have done today, and that's a good one. So then I think other than that, I will also just say to them, we are lawyers or we are students of law. So whatever it is that we have a presentation, let us strive to reflect what the courts have said or what some other administrative authorities have decided in case of similar case. And sometimes it may even be the bill that will look at that, well, apparently this is what applies. But a look at the Data Protection Bill 2023. This is looming on the horizon. So let us be as expansive as we can be. I think generally, and there's another thing. Maybe that group, Mr. Amanda, you may need to pack them with you, send some to Twitter, send some to Meta, send some to Apple, and I'll tell you why. These guys made beautiful presentation, but just like in-house counsel. So they some of us who do the my Lord, we are being left out. Let them write so that we can see that, okay, in the case of the Honorable Justice, my Lord, the apex court, no matter who are used to litigation, we love coming across that the apex court, the appellate court, in his wisdom, you understand. But I mean, though that's on a very light note, it still goes to the same thing I've said before, and I'm saying it again. Try to infuse your thoughts, your view with case law, wherever you can get them. Even if they are foreign, try to do that. Let it be that it does not exist at all. And that's the whole essence of what we call research. If you have a research should produce a result that shows our capacity. So in all, a very, very beautiful attempt, and I wish you guys the very best. Thank you.
You're muted. You're muted. We can't hear you.
All right. Sorry, sir. Sorry, I didn't notice. I said I was thanking our mentors for making our time to join us today, Mr. Solomon and Mr. Emmanuel, and also the mentees that joined the call. Our attendance for today is very poor. I will encourage the group leaders for next week to do better in bringing our all the mentees from the group to the call. Thank you very much, everyone, once more, and have a lovely day. Bye-bye.